Mhm.
Hello, I'm David Shulman, and this is my law partner, Jill Ginsberg. We're Ginsberg Shulman, an estate planning, probate, guardianship, and trust administration boutique law firm right here in sunny South Florida. Today, we want to talk briefly about pay on death and transfer on death accounts, what they are, why people like them, and where they can cause real problems.
David, a lot of people hear pay on death, transfer on death, or beneficiary designation and think, great, no probate. Just to level set, pay on death usually applies to bank and cash accounts. Transfer on death usually applies to investment accounts, and beneficiary designations usually apply to things like IRAs and life insurance. People are often told that these are fast, simple, and avoid probate. David, why is this a good thing?
Jill, there are real advantages sometimes. These assets pass automatically at death. There's no court involvement for any of these accounts. Beneficiaries will usually get access to the money quickly, and there's much less administrative hassle. Look, we're probate attorneys. We make our living through probate, but even we will say clearly, in many situations, pay on death and transfer on death are perfectly appropriate, especially for simple estates where there's one or two beneficiaries in situations where quick access to cash really matters. But Jill, pay on death and transfer on death aren't always appropriate. Why not?
David, the issue that most people don't see is this: paid on death and transfer on death assets don't go into the probate estate. Why is that a problem? It means that those assets aren't available to pay any funeral expenses, final medical bills, creditors, legal expenses, and sometimes taxes. So if there's probate only assets like real estate, someone still has to open a probate. And now the estate is cash poor, even if there were plenty of money overall. Unfortunately, we see this all the time. One child is named as POD beneficiary on a bank account. Another child inherits the house through probate. The paid on death beneficiary legally keeps the cash. It's legitimate. But the estate, which owns a house now, has no money to insure it, maintain it, or even sell it. This leads to family conflicts, outcomes that sometimes feel unfair, but really are legally correct, and court involvement anyway, the very thing that people were trying to avoid, because eventually people are going to wind up suing each other. So, David, what's the takeaway on this?
Jill, the takeaway is this. Pay on death and transfer on death are tools in the estate planning shed, but except in some very simple situations, they shouldn't be the entire plan. They work best when they're coordinated with the other assets in the estate and the overall estate plan. The real question isn't, can this avoid all probate? It's really, what problems might this create after I'm gone?
So, this is why estate planning isn't just about avoiding probate, it's about making sure that the plan actually works.
Thank you, Jill, and thank you all for watching.